Hello and welcome to day 2 of HINSHA's 25th Annual Labor Employment Seminar. Real disclaimer. The information presented today is not intended to and does not constitute legal advice, recommendations, or counseling under any circumstances. You should not act or rely on any information provided without seeking the advice of an attorney licensed to practice in your jurisdiction for your particular situation. In addition, the information presented during this session does not necessarily reflect the opinions of our clients. Again, thank you all for joining us, and let's get started. It is my great pleasure to welcome today's presenters, Tom Lukemeyer and Evan Bonnet.
Good afternoon. My name is Tom Lukemeyer, and together with my partner, Evan Bonnet, we are going to be discussing whistleblower and retaliation claims in the COVID era. And let me see if I can move the slide a little bit here. I may have you do that, Cheryl. All right. We'll get moving right along now. The goals of the presentation are relatively straightforward. Evan and I are going to be providing a description and an analysis of the types of retaliation and whistleblowing claims that employers might confront in the COVID era. Evan will be talking a little bit more about this later, but one of the laws that we will be discussing, for example, is the Chicago Ordinance. Which prohibits retaliation and interference. That statute, in addition to providing a remedy for reinstatement, also provides 3 times back pay damages for individuals aggrieved under the statute. It applies to employers who have 4 or more employees. And then there's an awfully vague phrase that talks about plaintiffs also be entitled to, quote, other actual damages. That might be associated with the lawsuit, and of course attorney's fees. We're going to be covering a variety of other claims as well. We're going to be talking about the Occupational Safety and Health Act, common law retaliatory discharge. We're going to be talking a little bit about Section 7 of the National Labor Relations Act, which basically covers every single employee in the country. Evan, of course, will be talking about Sarbanes-Oxley, Dodd-Frank, the False Claims Act as it pertains to the PPP, the FFCRA, which everyone by now knows is the family's first coronavirus response act. And we'll even talk a little bit about claims that employers might bring. One of those claims, for example, was just filed yesterday in Pennsylvania and dealt with an employer's claim against a union. And the suit came after the store discovered that there were signs posted in its worker break room and vending machine rooms that called on the workers to basically boycott overtime and make good use of the company's COVID-19 call-off policy. Now, the store believed that was a call to strike or a work slowdown, which was prohibited by the collective bargaining agreement, and they went ahead and filed suit in federal district court. We'll have to see how that one plays out. Cheryl, the next slide, please. We're going to start off with some key definitions. And as we will see, whistleblowing is one form of activity which is included in the broader context of retaliation. It becomes, as we will see, one of the protected activities entitled to protection. Now, Merriam-Webster defines a whistleblower as one who reveals something covert or informs against another, especially an employee who brings wrongdoing by an employer to the attention of government or law enforcement. Many states, and I'm not going to identify them all, but I'll raise one, for example. California prohibits employers from enacting policies that prohibit employees from disclosing information to a government agency or to a person with authority over the employee. That could be the employer. or to another employee who has authority to investigate, discover, or correct violations of noncompliance with any law. So California is a good example of a state that has a very, very, very broad Whistleblowing Protection Act, which obviously applies in situations involving COVID. Next slide, Cheryl. Let's go to retaliation. And what we're going to see is retaliation is commonly understood in the employment context as adverse employer action taken against an employee for engaging in activity which is protected. Now, in common parlance, we understand protected activity to include three things: oppositional activity, and that would be simply speaking out against unlawful activity, calling out an employer, for example, that they're non-compliant with safety protocols regarding COVID-19. There's participatory. Participatory is a good example is where you participate in an EEOC proceeding, or in the context of COVID, where you participate in an investigation by OSHA. And as we have seen, also whistleblowing. So these are the three common types of protected activity. Cheryl, next one, please. Evan's going to be discussing a little later that retaliation also can be based on a state's common law in the form of retaliatory discharge claims. Such claims are being used in the COVID area, and we're going to see a couple of examples of cases that have been filed just within the last couple months, where the allegation is that the employer has reached important public policy through the discipline or discharge of a particular employee. Prohibited retaliation under the common law of a state is often based on employer actions which frustrates what I just said, some clearly articulated public policy. These claims are narrow, must be based generally on a state's constitution, the laws of the state, or the decisions of its highest courts. That's the common law notion. Many statutes also include anti-retaliation provisions. So for example, Section 11C of the Occupational Safety and Health Act prohibits retaliation against employees who complain about unsafe or unhealthy conditions in the workplace. The early litigation that's being filed right now basically shows a jumble and a mix of claims. If you get a claim, one of the things we want you to make sure you mention to your counsel is the word preemption. Some of the claims that we're going to be mentioning today may preempt other claims, or may preempt other state law claims. Now, that's not the case for OSHA, for example, but it might be the case with respect to unfair labor practice under Section 7 and Section 8 of the National Labor Relations Act. Cheryl, you can go to the next slide. The preemption issue becomes important, by the way, because depending upon the nature of the claim and the proper forum in which it is to be brought, there may be no availability for punitive damages or perhaps even attorney's fees. Protected activity is the next concept where we have to have a good, clear understanding. We talked about the activities before in general terms: whistleblowing, number one, oppositional activities, number two, and participation activities, number three. But protected activity can take many forms. It could be a complaint to a regulatory agency. It could be a complaint to a law enforcement agency. Could be a report to an employer's board of directors. It could be a report to human resources or supervisory personnel. So you can see that protected activity could be made internally. It could be made externally. A word of caution, however, for those of you who may be interested in being plaintiffs or lawyers out there who are representing plaintiffs, some statutes require external complaints to trigger coverage and protection under the Act. Cheryl, next slide, please. Keep in mind that adverse action in retaliation claims is broader than in a discrimination claims. For example, not all employer actions are sufficiently adverse to trigger exposure under many laws. The application of the concept differs depending on the statute. In some cases, the same statute will have different concepts for adverse action. So, for example, what is considered adverse under Title VII for a disparate treatment claim may differ from the same statute's application of the anti-retaliation provisions. The most notable case in this regard is a 2006 Supreme Court case, Burlington Northern versus Santa Fe Railway Company in White. And in that case, the court said that you have to assess the relative severity of employer actions, and it must be context specific. That means that what might be retaliation in one workplace might not be retaliation in another workplace. And in determining whether the harm is sufficiently adverse or significant, the court should use an objective standard to assess the impact on a reasonable employee in that particular workplace. So, for example, in Burlington Northern, the employer made a job assignment which was within the job description of a laborer. However, based on the facts and circumstances of that case, the court held that it was behavior which nevertheless chilled the protected activity. So the lesson here is to make sure that you do not necessarily assume that adverse action must rise to the level of a discharge or a demotion or some other very significant adverse action. Cheryl, the next slide, please. We'll give you a good example with respect to OSHA. OSHA actually, in its publications, says that adverse action might be subtle, not always easy to spot. So in addition to terminations or demotions, which most certainly are adverse actions, OSHA has identified reassignment to a less desirable position, actions which might affect prospects for promotion, such as excluding an employee from a training meeting, falsely accusing an employee of poor performance, intimidation toward an employee, denying overtime, or a denial of benefits. So why are retaliation claims so concerning to employers, for lack of a better phrase? Well, the proof paradigm is relatively simple. Unlike a traditional disparate treatment or disparate impact claim, which has its own proof paradigms, under retaliation, a plaintiff must allege whistleblowing or some other protected activity under a specific statute or related to a substantial public policy. Then the plaintiff must allege adverse action, some form of interference or specific harm that rises legally to the level of adverse action for a retaliation claim. And then simply some sufficient evidence to establish a cause and effect relationship between the protected activity and the adverse job action. Now, it's important to recognize that you don't need necessarily direct evidence to establish the cause and effect relationship. Circumstantial evidence also may be used to establish it. And what's the circumstantial evidence? Could be comparative evidence on how you've handled situations in the past, or it may be evidence which tends to refute the reason that you articulate, the employer articulates, in other words, for the adverse job action. Cheryl, next slide, please. Let's talk a little bit now about some of the specific statutes that you need to be aware of. We mentioned the Chicago statute earlier. Evan's going to be describing a few more. I'm going to spend a little bit of time focusing on OSHA and COVID. And by the way, at the end of the presentation, like most Hinshaw presentations, we're going to spend quite a bit of time talking about best practices and how to handle claims of retaliation, claims of violations of whistleblowing in the workplace, and the things you can do to mitigate the risk. But first, let's get a good handle on where these claims are coming from. And the first is under the Occupational Safety and Health Act. And OSHA, for those of you who are familiar with it, knows that they have a separate division which investigates retaliation claims. And they have a very detailed procedure, administrative procedure, which allows such claims to be investigated and adjudicated. Now, with respect to COVID, the four most relevant OSHA regulations are the personal protective equipment standards, PPE in other words, at 29 CFR 1910. The general duty clause, and notice we're providing citations for all of this. The general duty clause is actually found in the text of OSHA itself, section 5A1, and that requires employers to provide a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm. Cheryl, next slide, please. The third, which you'll see, is OSHA's death and inpatient hospitalization recording and reporting requirements, which are found generally at 29 CFR Part 1904. And for those of you who are keeping up with the reporting requirements, you recognize that on October 6th of this year, just approximately 3 weeks ago, OSHA clarified its reporting requirements. And so with respect, for example, to a hospitalization, an inpatient hospitalization, that is, if it's deemed to be work-related, a report must be made within 24 hours of the work-related incident. In other words, within 24 hours of not only the hospitalization, but the employer determination that it is actually work-related. With respect to fatalities, they also have to be reported. And any fatalities associated with COVID-19 must be reported to OSHA if the worker dies, and it must be reported within at least 30 days of exposure at work. But that's not it. You also have to do so within 8 hours of knowing both that the employee has died and that the cause of death was work-related. And for those of you who would like a citation on this, it's 29 CFR 1904.39. So you'll want to make sure that you comply with OSHA's reporting requirements in this regard. The last one is not really applicable to COVID. It's the bloodborne pathogen standard, and those of you who are in the healthcare industry are probably very familiar with this one. But note that while this standard typically doesn't apply to respiratory secretions, in other words, the way COVID is transmitted, the standard does provide some helpful guidance and a framework for prevention. Cheryl, next slide, please. You can see that OSHA's whistleblowing claims are on the rise. The Office of the General Counsel of OSHA has noticed a significant surge in whistleblowing complaints. While those complaints increased generally from 2019 to 2020, OSHA's whistleblowing program employee count, in other words, the number of FTEs, has actually decreased. And the OIG also noted that 39% of all whistleblower complaints received between February 1 and May 31 of this year were related to COVID-19. Now, this has resulted in even greater delays in the agency's investigation of these types of complaints. Next slide, Cheryl. In fact, you can go to them, actually. Those of you who are familiar with the investigation of OSHA claims know that it takes a while to resolve them. Even on a good day, it will take at least 90 days from notice of the claim to resolution by their OSHA retaliation investigators. And if I didn't mention it before, I'll mention it right now. OSHA has a separate team that investigates retaliation claims. You should expect probably at this time in 2020 that OSHA investigations regarding retaliation and whistleblowing probably will be resolved no sooner than 6 months after you first get notice of the charge. Now, why is it we care? And you'll see that for a lot of these statutes, we care because employees can be entitled to reinstatement. They can be entitled to back pay. They can be entitled to any loss to benefits they incurred as a result of adverse employer action, and attorney's fees as well. Employees under OSHA must follow an administrative scheme. And if the investigation results in a determination that there's merit to the claim, the Department of Labor may choose to litigate in federal court. In other words, an assistant solicitor for the Department of Labor is going to take up the case for the aggrieved party. If the claim is dismissed after an investigation, it can be appealed internally before OSHA, but an employee generally cannot bring a civil lawsuit under the Act. With that, I'm going to turn it over to Evan, who is going to talk about the other types of claims that could be brought in this era related to COVID-19.
Hi, good afternoon or good morning, depending on your location. This is Evan Bonnet. It's nice to be here talking with everybody. So one of the things that we, as we talked about OSHA, we've been focusing on the Occupational Safety and Health Act, which is administered by OSHA. Same abbreviation, Act versus administration. But one of the things that is also worth noting is that OSHA is also responsible for the Whistleblower Protection Program for this eye chart of information. So there are more than 20 federal laws that OSHA is responsible for protecting, and includes this various and sundry list of things, which includes not only workplace safety and health, but aviation safety, commercial motor carrier, consumer products, financial reform, food safety, railroads, nuclear safety, and securities laws. I'll talk a little bit more about securities laws in a minute. We've included the time frame on here. Each one of these statutes that directs the enforcement to OSHA provides a different time frame for that administrative process that the employees or anybody filing the complaint under for retaliation must follow. But it's worth pointing these out because it shows that OSHA is dealing with more than just workplace safety. Obviously, when it comes to COVID and retaliation issues, that's one of the primary concerns, but it's not the only one. So it's worth thinking about and reviewing some of the other areas where some topics of concern may arise. Okay, as shown by the previous slide, another area of retaliation law that's administered by OSHA is under the Sarbanes-Oxley Act. This is a Securities Act. It's often overlooked when it comes to employee retaliation under the OSHA administrative regime, but it's definitely something that could potentially come up here quite a bit, especially when we're talking about the amount of financial aid, grants, loans, I mean, trillions of dollars that are floating around out there right now in government assistance. The opportunities are a lot of opportunities for employees to notice wrongdoing and report it. SOX is from 2002. It covers securities registered under the Securities and Exchange Act, as well as protecting employees of publicly traded companies or companies that have to file reports with the SEC. This protects employees from retaliation or reporting alleged mail, wire, bank, or securities fraud, or violations of SEC rules and regulations or fraud against. It's somewhat easy to see that connection between the possibility of some wrongdoing when it comes to the money that's been received from the government, or perhaps reports that are being given to shareholders as the economy goes up and down, and SOX. Now, again, complaints are filed with OSHA, and that handles the investigation. The Dodd-Frank Act of 2010 also deals with securities-related issues in a slightly different manner that's kind of outside the scope of this discussion. But a key point there is that it is not administered by OSHA. It creates a separate SEC whistleblower office and permits, and in fact, in a lot of cases, requires anonymous filing. So while that's going to minimize some employment-related claims for you, because obviously you can't retaliate against somebody if you don't know who they did it, that doesn't mean that you're not going to be having guesses, which is one of the kind of things we'll talk about with our best practices. However, Dodd-Frank, again, not administered by OSHA, so this one is separately administered by the SEC, also includes strong anti-retaliation provisions, includes double back wages and the ability to file a claim directly in federal court. That's, again, a key difference from anything administered by OSHA that requires the administrative claim, has some appeals within the administrative process, but then only permits the filing in federal court if OSHA, on behalf of the federal government, wishes to proceed. Now, another issue, and that really came to mind for me when thinking about potential whistleblower issues, is the False Claim Act. So I'll point out Dodd-Frank also includes what's called a qui tam provision. You see that on the slide here. We like to use outdated Latin whenever possible. And what qui tam essentially means is that an individual is allowed to sue on behalf of the federal government. The False Claims Act is one of the most powerful anti-fraud statutes, and it essentially involves claims filed against the government. So this is a way that whistleblowers can report suspected fraud and abuse when that fraud and abuse is connected with a claim that's been filed against the government. The Department of Justice may elect to pursue those claims, but even if it declines, the qui tam provisions mean that the individual who is called the relator can decide to pursue those claims on behalf of the government, his or herself. The FCA prohibits the knowing, reckless, or indifferent submission of false claims for payment to the government. Violations include fines as well as treble damages. The fines of over $23,000, for instance. You can see some numbers in here. In 2019, the individuals who acted as relators, either from initially kind of blowing the whistle for the government that this was happening or proceeding with the claim on their own on behalf of the government, earned $270 million. They can get 15 to 30% of the recoveries depending on how much they help, basically. Now, 2019, that was about $3 billion in FCA judgments and settlements. That was obviously before we had a $2 trillion or so package out there. So the risk is real that employees who have information information of wrongdoing may be out there and potentially exposing this information. Now, why does it matter that they may be employees? Anybody can bring a qui tam claim. Now, to do so, however, requires knowledge. You have to be able to substantiate the claims. You can't have a conspiracy theory out there and decide that that's what should allow you to proceed the relator. So individuals with insider knowledge, perhaps an accountant or somebody else who's been handling your books, just as an example, are going to be most likely to be the person who has that information that would be reported. Numerous individuals are protected here if they blow the whistle. Employees or contractors are protected. It also includes agents, and retaliation is broadly defined here as retaliation in the form of being discharged, demoted, suspended, threatened, harassed, or in any other manner discriminated against in the terms and conditions of employment. It doesn't mean just fired or given a suspension without pay, for instance. This has some teeth to it and is a broad definition of retaliation. Now that you've learned of a whole new cause of action you may not have heard about, why should you care? So this is why. This is a particular concern, I think, because of the COVID Economic Injury Disaster Loan, that's the grant program that's out there, or the Paycheck Protection Program, the PPP. Both of these are very common. They were properly used by almost everybody, but of course the information is out there in the public when they release that information in the summer about who received what. And obviously you had to make certain certifications under that program that all would be able to be included as a claim to the government. So I mentioned that the FCA applies to claims made to the government. The certifications you made under these programs leave employers at risk of somebody who has inside information being able to document that. And going into detail on this, I think makes some sense just so that you understand this isn't necessarily just going to be a matter when it relates to COVID of somebody being concerned for their safety at the workplace because of safety protocols that are being followed. There's also potential risk when it comes to this. So among the different things that were being certified, of course, under the FCA, so obviously you had to provide information about being eligible for PPP loans, that you spent it as required, and that it was necessary for ongoing operations. So any documentation, anything like that that may expose liability and that concern, of course, is going to be an issue. Anything with qui tam, especially under this, is going to really need an attorney involved. Obviously, attorneys are going to be interested in bringing these types of cases because they involve attorneys' fees. that involves double back pay, interest on the back pay, reinstatement of employment, special damages, which, as Tom mentioned, the Chicago ordinance can be vaguely defined sometimes. There are, just like a lot of plaintiffs' counsel, there are people out there who are interested in bringing these cases. They're obviously lucrative from the amounts of money that I talked about, and should be of particular concern to anyone in a highly regulated industry. Healthcare and federal contractors come in particular to mind because of the amount of regulations that are arise under that area of the law. So we'll talk a little bit about steps to help prevent or minimize retaliating against whistleblowers. When it comes to things like your PPP loans, for instance, protecting against that actual claim, of course, is really the scope of a different webinar and a different discussion. But the more that you've got everything documented about how you spent that money, the safer you are really from preventing a whistleblower issue, because the documentation is there that everything was on the up and up. So in addition to those securities issues and false claims issues, there's a few other laws that are worth pointing out under the COVID regime, if you will, of things that we need to be worried about. The first is the FFCRA, the Families First Coronavirus Relief Act. This is the one that provides a number of paid leave provisions, expansion of emergency paid FMLA leave. Primarily these are to provide time off for individuals seeking a diagnosis or who've been diagnosed with COVID, caring for a family member, or unable to attend work because of, for instance, the school being shut down. The exact scope of those laws is also another hour-long discussion, and definitely worth learning more about if you're unfamiliar with it. Key for this discussion, however, is that the FFCRA also provides protections for individuals who use or request to use those benefits. There is no administrative action required first, unlike a lot of other employment-related cause of actions. In the discrimination claims, for instance, discrimination claims handled by the EEOC, for instance, or the OSHA ones we talked about, where there's an administrative claim you have to follow first. Individuals can file a claim under the Fair Labor Standards Act, the FLSA, with the Wage and Hour Division of the Department of Labor. But they can also bring these claims under the FFCRA directly to federal court. Claims here started really almost contemporaneously with the beginning of the statute. There were some in the April timeframe, for instance, of individuals who had requested time off and were already seeing terminations and other negative actions for requesting those times. They're all still in the hopper, if you will, so we don't really know what the outcome is going to be on those, but we do anticipate seeing a lot of these as add-ons to other claims. So if you've already got an issue where you're being terminated, maybe a discrimination issue, maybe a wage and hour claim, something like that, we'd expect to see something like this being added on to that, especially if even, for instance, an attendance issue is asked for time off under the FFCRA, they now have an additional cause of action. This has the same remedies that's under the FLSA, so that again includes liquidated damages, which is an amount equal to the lost wages for willful violations, as well as attorney's fees and others. Another issue that Tom brought up is state causes of action, known as retaliatory discharge. Well over half of the states have something like this. We'll talk about a case in Kentucky, for instance, in a little bit. But that includes, key for us, I think, California and Illinois recognize a cause of action for discharge and contravention of a clearly mandated public policy. So really, the clearer your, for instance, executive orders or health department regulations or orders are, and an employee is attempting to enforce, for instance, mandatory mask wear, and the employee is terminated for that, just as an example, they are going to have a potential cause of action under retaliatory discharge. An employee who is fired because she refuses to violate the law also has a valid claim of retaliatory discharge. So if for instance, you've been shut down and you open anyway, and an employee refuses to do so, also just as an example, that employee also, at least in Illinois, would have a potential cause of action for retaliatory discharge. Interestingly as well, I talked about the securities issue, there may be one here too. So if somebody were to be a whistleblower under a claim for government assistance, for instance, and this employee says that they shouldn't have received that assistance, following full disclosure, truthfulness, and accuracy in financial reports, and insisting on not lying on those, for instance, can also be retaliatory discharge. Now, California and Illinois, for instance, also have statutes. Illinois has the Illinois Whistleblower Protection Act, and California has a robust statute in its California Labor Code, both of which prohibit retaliation against an employee for disclosing information that violates a state, federal rule, or regulation. And last, Tom mentioned the ordinance that's been passed that protects against retaliation for following stay-at-home orders, quarantine, medical orders, or isolation orders. This applies to all employers with 4 or more employees. The city can pursue action at administrative hearings or in court directly against the employer, or the employee can institute a civil action, obtain reinstatement, triple damages, actual damages, and attorney's fees. So again, there's a number of things out there, all of which should be considered when kind of learning about our best practices that we're going to be discussing in a little bit. Okay. Now, here's what we are seeing in some claims. Typically, these are related to some of the issues we've talked about already. So that is not being provided appropriate PPE, reporting incidents or not reporting incidents, or maybe an individual who is responsible for recording incidents is being told not to do so. Another issue we'll talk about in the best practices is employees who don't want to come back, or employees who aren't being allowed to return. Employees who are being terminated or suffering adverse actions for speaking out with regard to patient protections, and also employees who are being perhaps placed on furlough versus other ones. Lots of different claims that are arising when it comes to COVID and concerns that are out there. So I mentioned the Trader Joe's case out of Kentucky. This one involves Kentucky's retaliatory discharge claim. And in this individual, King is his name, alleges wrongful termination in violation of Kentucky public policy. Essentially, he alleges he was terminated because he complained about workplace safety during COVID-19. This is in the very, very beginning of it, before a lot of places like Trader Joe's and grocery stores were putting up plexiglass barriers and those sorts of things. So this was the very beginning of trying to follow both the Kentucky governor's executive orders and the beginning of CDC guidance. Interestingly, King also alleges he got COVID symptoms and was quarantined during the beginning of this, kind of complaining to his employer on these issues. And after he first complained about the lack of gloves, he says that he was fired. At some point in time, he also creates a private Facebook group or page with other employees, and they start discussing concerns amongst themselves about that lack of support and a lack of implementation of the safety measures. You can see here what those posts included. Tom's going to talk about some of the Section 7 concerns that arise under this, which are substantial. But ultimately, the grocer alleges they terminated King on a pretext. Among them was the fact that I liked out of this one was jokingly tossing quinoa at a coworker. So things that were raised earlier, this is all 2019 stuff, that suddenly didn't become important until the complaint was raised, which again is an issue that we will discuss when it comes to best practices. Finally, another case in point is a recent Amazon suit. In that, an employee who was tasked with enforcing distance and mask wearing protocols in particular, in this case, went up to a supervisor and informed him that he was talking too close. I think he alleges something like 2 feet away from somebody else. And in response to that, the supervisor would, every time he saw this individual, allegedly would stand closer to the person he was talking to, about a foot away. So the employee raised the level of his concern up the chain chain of command, if you will, and was ultimately terminated from that. So this one is in the very beginning stages. These were obviously all allegations, but definitely wanted to raise these types of concerns and keep those in the back of your mind as we move next to the beginnings of best practices. With that, Tom, take us away on Section 7.
Yeah, I'll talk a little bit about Section 7 rights. It'll be interesting in the Trader Joe's case to see if the employer actually raises that preemption word we talked about before. All employees in the United States that are employed by a covered employer, and that's pretty much everybody, have Section 7 rights. And Section 7 of the National Labor Relations Act, 1935, has one of the most power-packed short provisions in all of labor and employment law. Section 7 provides employees with the right to self-organize, to form, join, or assist labor organizations, to bargain collectively, and most importantly, for purposes of COVID in our discussion here, to engage in other concerted activities for mutual aid or protection, as well as the right to refrain from any and all such activities. And the National Labor Relations Board, for example, in enforcing the unfair labor practice provisions under Section 8 of the Act, have said such things as employee posts on a private Facebook page where they invite other employees and they discuss terms and conditions of employment. That's protected activity. So Mr. King's Facebook posts may have fallen within the scope of protected activity within Section 7. And what you want to make sure that your supervisors know is that employees who discuss with each other safety issues related to COVID and even complain about the employer, and maybe even complain in what you might call not so polite terms, they're likely within the realm of protections of Section 7. And in the event there is adverse action, as we said before, such as a demotion or a termination, employees could file an unfair labor practice charge under Section 8A1, perhaps even under 8A3 of the Act, and seek remedies. One of the things and one of the important aspects about claims brought under the National Labor Relations Act is that the board typically moves a lot more quickly. When I say the board, I'm talking about the National Labor Relations Board. I mentioned before that an OSHA investigation might take 6 months. When you're dealing with the National Labor Relations Board on a Section 8A1 claim, you might be through the investigation in half that time. So be very, very aware of employee rights under Section 7. And if you'll move the slide forward, actually move them 2 forward, 1 more. Now, we're going to talk about best practices, and we have a good 12, 13 minutes left. And as we do in most Hinshaw presentations, we like to have you walk away with a good understanding of some of the things you can do to mitigate the risk in these times. Now, not all of the practices that you're going to see here are appropriate for your workplace. You have to consider the size of your particular workplace, the nature of the industry, the type of workforce you have. Is it clerical? Is it skilled trade? Is it production? Is it sales? Is it professional? So depending on the nature of your workplace, some of these may fit and some of these may not fit. But let's try to keep it simple here. Best practices are really summed up by letting your employees know what you're doing, letting them know what they can do if they have a concern. Think about what you might be doing for harassment situations under your anti-harassment policy. Think about what you might do for safety considerations in the workplace. You hear a lot, safety is job one. Make sure you report a safety practice or a safety violation that you believe needs to be raised to management. Do the same thing for COVID-19. What you want to do is you want to create not necessarily an anti-retaliation program, but really an atmosphere where employees could feel free to report a hazard. I found that many disagreements with respect to COVID-19, which could lead to retaliation, which could lead to harassment, which could lead to a whistleblowing claim, might stem from the fact that employees don't really understand or know what the employer has already been doing. So create an atmosphere where employees can come forward without fear of retaliation, just like they can come forward without fear of retaliation in the event they have a harassment claim. Educate your management and staff on the environment that you want to promote. Make sure that your managers are aware of the various laws that may be implicated with respect to COVID-19 decision-making. Whether it's the securities laws that Evan mentioned, whether it is the National Labor Relations Act that we just discussed, or the specific anti-interference provisions that we find under the FFCRA or even under the state's common law. Make sure your managers know that there are probably no fewer than 8 to 10 different statutes which could be raised by a savvy plaintiff's lawyer in the event there is adverse action against one of your employees. You have to make sure that your managers understand the safety complaints generally are protected. They may disagree with the employee. Always assume that the employee is acting in good faith unless you know otherwise. And just like you have in your harassment policy, make sure that you have uniformly applied consequences, discipline in other words, for non-compliance with policies on reporting and anti-retaliation. I know that OSHA has changed its rules with regard to the prohibitions per se of certain incentives that may be given to employers or workers with respect to keeping injury rates low or perhaps discouraging even the reporting of these things. Keep that in mind because you definitely do not want to create what I would call unsatisfactory or bad evidence. Next slide, please. Many employees simply just don't know what the employer is actually doing. Perhaps they just haven't been paying attention. But doing something as simple as creating a simple update as to what's happening in the workplace, what you've done in terms of establishing social distancing requirements, what you've done to deal with positive test results in the workplace is very important. Employees want to know ultimately that they're safe and that their coworkers will be safe. And if they believe that you're taking reasonable precautionary measures, I think you'll be okay. Part of this means, and you can do this in a number of ways, educating your employees on COVID-19 prevention. And as I said, inform them of the steps you're already taking. Understand that COVID creates anxiety for some employees. Some of us care more than others about the spread of the infection. Not that anybody doesn't care, but some of us are a little bit more cavalier about it. But educate managers on how to diffuse conflict between employees who may care at different levels and allow them to move forward constructively. Again, provide that mechanism, an outlet for raising safety-related complaints, sometimes even confidentially if appropriate, because if an employee can't complain to you, then they may complain elsewhere, which is the start of a whistleblowing problem. One thing to do is publicly recognize employees who bring issues to light and suggest meaningful preventive measures. This shows that what you're doing instead of harming, disciplining, reacting to in a negative fashion employees who think too much about safety, you're actually encouraging employees to keep safety in mind as they move forward. And with that, I'll turn it back to Evan for the conclusion of a couple of slides on best practices.
Okay, thank you, Tom. So one of the mechanisms that we would recommend for that is, again, appropriate with your workplace and how you're organized, how large you are, what you do, whether everyone is they're physically or working remotely right now, or any combination of that, is having multiple or alternative mechanisms for reporting. Redundancy, in other words. What seems to be a common issue when it comes to retaliation or just issues developing generally in this area is there being one weak spot. So everybody has to report it to one particular individual who isn't, as Tom mentioned, maybe perhaps taking COVID seriously, or has a personality disagreement with the person who's reporting it. There's all sorts of reasons why one particular individual or one particular method may fail. So having multiple methods is a possibility, depending again on your workplace and how you're organized, to be able to safely provide an opportunity for reporting safety concerns. Also concerns related to COVID and other health issues. In particular, if there is a way to do that anonymously, it's going to cut down on the proof available, if anything else, that somebody was the one who did the reporting and is now alleging that they've been retaliated against. Safety complaints should be promptly documented and action taken. Don't let it fester. Don't let the example I always have in my mind that relates to employee discipline, but applies here, as you wait for the stack of complaints to get this big before you do anything. At that point, you should still do something, but it's really too late. You've let it get worse before you've taken action. So take action immediately, or as soon as you can after an investigation is concluded. Another big key piece when it comes to retaliation is don't take it personally and follow through. So even if an employee's complaint seems trivial, even if an employee is the squeaky wheel, even if the employee, as Tom mentioned earlier, doesn't phrase it in a polite manner or some way that you approve of the language that was used or the tone, or you don't like that they went to this person above your head as opposed to this other person, all of those are not reasons to ignore the complaint. And in fact, seem to be the beginning stage of a lot of problems that we see once we get involved, is that something was ignored or dropped or whatever because they didn't like the employee, or the employee was already kind of a problem. Another option is considering teleworking if that's available. And we have policies and recommendations in place when it comes to an employee teleworking who's not normally doing that we'd recommend. You talk with your counsel or experienced legal counsel regarding that to make sure that it doesn't become accidentally a reasonable accommodation for everyone. Refusals to work, wanted to talk about that one as well. So employees should not leave the workspace merely because they filed a complaint. There's a whole process that they need to go through. Essentially, they need to ask the employer to eliminate the danger, and it hasn't been done. The refusal has to be in good faith. The reasonable person has to believe there's a real danger of death or serious injury, and there's not enough time due to the urgency of the hazard to get it corrected through proper channels, such as requesting an OSHA inspection. So that's the OSHA standard for refusing to work. It's hard to meet. It's not impossible, but it's hard to meet. So don't let an employee just say, I'm refusing to come to work and get away with that. That needs to be addressed, but understand that there are ways for an employee to go through that process and be protected. Sometimes, and we mentioned this with the quinoa throwing incident from the Trader Joe's, sometimes you have to take an action against an employee who has filed a complaint. Anyway, it's not related to the complaint, but you need to be able to show that it wasn't related to that complaint. And this is always a big issue when it comes to retaliation. So general recommendations are here, broken down between performance-based issues and discipline-based issues. If performance is the issue and the employee has raised safety concerns, make sure the reason for the discipline or whatever action is being taken regarding performance is backed up by as much as possible specific objective evidence. You don't want to have last year's performance report be good and then all of a sudden it's only bad, or there's only concerns about productivity or how much money is being made or something like that after the employee has complained. Document things when they happen. Don't wait again for that stack of everything to get big. Same thing with disciplinary issues. Conduct an examination, for instance, of comparative discipline and how that has been imposed on other people who have done the same thing, so that you can make sure that you can say, employees 1, 2, and 3 did something similar and they received the same suspension that our complaining employee has also been given. and this will help to show that it wasn't being given because of the having blown the whistle on a safety concern. So with that said, I think we've rolled directly into 1 o'clock. Thank you very much for your time this afternoon and listening in on our discussion of whistleblower protections in the COVID era. It's been our pleasure to present this. And Tom, if you have anything else, I'll turn it to you.
Yeah, thank you very much for attending. I've been watching a number of the questions come through, and I will tell you that they're very good. We will announce, answer all of those questions. I will just answer one, and that deals with the with whether or not the OSHA 300 reports have to be posted given this this time frame. And yes, they should be posted as of February 1. There's a window of February 1 to April 1. And the question, I think, is whether or not you can post them electronically, given the fact that a lot of people are working remotely. I'll tell you, a lot of agencies are moving toward electronic posting. The EEOC is doing it. The National Labor Relations Board is doing it in many circumstances. OSHA hasn't come out and said you need to. So right now, you still just need to post it at a common area in the workplace. Certainly, there would be no prohibition against you posting it electronically if you wanted to. So that's a good question. We'll probably see similar questions and similar answers on Friday, and we hope you all will come visit us, even though it's virtual. Thank you very much.